Well, good morning or afternoon, everyone, and welcome to the second session on how businesses can operate in conflict-affected and high-risk areas while upholding human rights. I'm Lara Strangways, I'll be your moderator for today, and I'm a director at Beyond Human Rights Compliance and the head of business and human rights at Global Rights Compliance. It's really great to see so many of you joining on this topic, and I think it promises to be a thought-provoking conversation today. For some of you that joined in February, we explored whether businesses can avoid complicity in international crimes, examining legal risks, responsibilities, and accountability frameworks. And building on that foundational webinar, today we will be focusing on the applicability of international humanitarian law, or IHL, to businesses. So IHL obviously has traditionally been seen as governing the conduct of states and armed groups during conflict and is increasingly relevant to companies who are operating in these environments. Whether that's through supply chains, security operations, infrastructure projects, businesses can find themselves navigating complex legal challenges. And today we'll use this hour to unpack some key questions, such as what are the corporate responsibilities under IHL and international criminal law? What are the lessons from the Lafarge case that we can take, including what went wrong and what businesses can learn? And how can companies ensure responsible decision-making in these high-risk environments? We have an excellent panel of experts for this discussion today, and I will introduce them shortly, but first a few quick housekeeping notes. We have a 60-minute session today, so that will include presentations for around 40 minutes, and then we're dedicating 20 minutes to a Q&A session. We'll aim to keep each speaker's remarks concise to allow time for that discussion to take place. As always, we encourage engagement, so please do submit your questions via the Q&A box at any time, and we'll try to address as many of those as possible during the discussion or in that 20 minutes. If you experience any technical difficulties, please contact Yuri or the support in the chat. And finally, this session is being recorded, and that means that we can share those slides in this conversation afterwards, including key takeaways. So with those housekeeping points covered, let's just quickly dive into some introductions. Today we have Clara Gerard Rodriguez, who's a senior legal advisor at Beyond Human Rights Compliance and a member of the Paris Bar. She has over a decade of experience in international criminal law, international white-collar crime, and corporate liability. She's counsel at the Parisian law firm FTMS and consulting with Beyond. She previously worked in defense and victim teams before the International Criminal Court and has been a member of GRC's mobile justice teams for Ukraine. Clara assists French and international corporations and corporate leaders in judicial proceedings involving violations of IHL, IHRL, and due diligence obligations before French courts. So she's very well placed to take us through some of those frameworks today. We're also joined by Wayne Jordash, KC, with internationally recognized expertise in international human rights law, including in the Legal 500 UK, as one of the world's leading international criminal lawyers. Wayne has advised states, the UK, the Netherlands, Ukraine, Bangladesh, Libya, Serbia, and Vietnam, as well as multilateral organizations, business, industry bodies, and civil society organizations. And I won't take you through the very long list of those. But he has provided a range of services to build monitoring, protective, and preventative systems to ensure compliance with UNGPs, domestic and international law. So with those introductions, I want to thank you all again for being here. And to start us off, I'd like to first turn to Clara to take us through the new French Red Cross guidance that will hopefully help to frame this conversation. Over to you, Clara.
Thank you, Lara. Good morning or good afternoon to you all. You may have seen that the French Red Cross published very recently a new guide on businesses and international humanitarian law. This is the latest of many new publications on how IHL, so international humanitarian law, applies to businesses either directly or indirectly, and what does it mean for businesses? How should they keep this in mind when operating in conflict-affected areas? So the French Red Cross Guide is at the moment only available in English, but in French, sorry. But we thought it would be a good idea to give an overview of it in English, as it can fuel our conversation today and give a good understanding of where the Lafarge case that Wayne will lastly talk about fits within this framework. Just as a very quick recap, what do we talk about when we talk about international humanitarian law? IHL, also known as the law of armed conflict, of the law of war, is a set of rules that bind on the parties to an armed conflict. That's the very first thing to keep in mind, is that IHL doesn't apply directly to businesses or other actors that are not direct parties to an armed conflict. But as we'll see, it is still relevant for businesses and corporations to keep this legal framework in mind in the conduct of the operations. IHL is built on three core principles: distinction, precaution, and proportionality. Distinction means parties to an armed conflict must always distinguish between civilians and combatants, and between civilian objects and military objectives. Precaution means that while conducting hostilities, the parties to an armed conflict must always minimize the harm caused to civilians and the damage caused to civilian objects. They should take all possible measures to minimize this harm, limit unnecessary sufferings of both civilians and combatants. Proportionality, lastly, means that the parties to an armed conflict must always ensure that the incidental harm to civilians, the loss of civilian lives, injuries to civilians, or the damage to civilian objects is always proportionate to the military objective, and not excessive in relation to the objective sought after by the hostilities. So where do businesses fit in that? Well, first, and that would be the next slide, thank you, businesses are protected by IHL in their capacity of civilians. We just said civilians are protected from attacks in conflict by the principle of distinction and precaution. And businesses, when they do meet this definition of civilians, when they are not a member of the state or non-state forces that are parties to an armed conflict, are benefit from this protection. This means practically that civilian businesses' employees, leaders cannot be targeted, that businesses' infrastructures are equally protected. This protection includes to civilians, to the personnel of the company, of the business, but also to civilian objects, so its infrastructures or its products, its supplies. Now, there are some situations in which businesses may lose this protection, and this is when they start taking a direct part in the hostilities. And this is maybe the first thing that we really want to focus on, is that the protection granted to civilian objects, and therefore to businesses, business employees, and business infrastructure is not definitely set. It is subject to the business conduct, and some of its conduct may trigger a loss of this protection. This will be the case when businesses take part in the hostilities, either directly through their activities or through their employees, their contractors, or through the use of their infrastructure. We cited a few examples here, but that could, for example, be the case when businesses take directly part in the hostilities, for example, by providing tools used in cyber warfare or in military intelligence to the warring parties. It can also be the case when businesses provide finances or material support to the parties to an armed conflict, including arms and ammunition, intelligence, satellite communication, any material or immaterial in some cases, support to the warring parties. It can also be the case, and this is a situation that we've seen quite frequently in cases related to business conduct in conflict-affected situations, is the hiring of military personnel or private military forces to secure the business's infrastructure. Well, if those personnel that are hired by the company to secure its site are somewhat involved in the hostilities, they lose protection. They can be considered as taking a direct part in the hostilities, and they may trigger a loss of protection for the business itself. This can again be the case for allowing business infrastructure to shelter combatants or to store weapons that are then used by the warring parties to conduct hostilities, or again by transporting combatants, military equipment to the front line. So this is just a few examples of all the behaviors, conduct that businesses may engage in when they are operating in conflict-affected situations that would trigger a loss of their protection and therefore make their activities, their employees, and their factories, infrastructure, legitimate targets to the parties of an armed conflict. So businesses who want to enjoy the protection granted to them by IHL when they operate, when they are present in a location affected by conflict, must always refrain from taking direct part in hostilities, for example, by engaging in those different conducts. The second way that IHL has an impact on businesses, and that would be the next slide, is that although IHL doesn't create direct obligations on businesses, it creates direct obligations on the parties to an armed conflict, and the violation of this obligation may in turn has an impact on businesses. We'll go through this now. So as we discussed, IHL only binds on the parties to an armed conflict, that being state forces, non-state actors that are involved in the hostilities. IHL set out quite a long list of rules, either because they are contained in what are called conventional international humanitarian law, so treaties, conventions that limit what parties to an armed conflict may do and provide some prohibition as to what they may do in the context of the hostilities, or by customary international humanitarian law. These are non-written rules that have been developed by practice and by the belief from the parties that they must comply with these obligations. The main, like the core obligations, are the ones that are included in Article 3, common to all 4 Geneva Convention, and that are the minimum set of rules that apply in the context of a non-international armed conflict. So a conflict like the one in Syria that we talked about later, that involves actors within one territory when not third party, so that third state intervention in the conflict. Conflict of an international character, so conflict between the forces of more than one country, are concerned by a larger set of rules. But these minimal rules that apply to non-international armed conflict include the prohibition of violence to life and persons, in particular murder, torture, mutilation, cruel treatment, the taking of hostages, outrages upon personal dignity, so that would be humiliating, degrading treatment, or the passing on unlawful sentences and carrying out of extrajudicial execution. These rules apply not only to civilians, but also to all those who do not participate in the hostilities, including wounded or sick soldiers who have been captured and made prisoners of war. Aside from these core rules provided for by Article 3 of the Geneva Convention, customary international humanitarian law has developed a long list of other prohibitions, including the prohibition of rape and sexual violence, slavery, forced labor, the use of human shields, enforced disappearance, deportation or forcible transfer of population, looting, plundering, causing serious damage to the natural environment, as well as the prohibition of certain weapons, for example, chemical and biological weapons, cluster bombs, mines, because they do not allow the parties to respect the core principle of IHL that we discussed about precaution, proportionality. There's also a different set of rules that apply specifically to situations of military occupation. So the forces of an occupying power occupy the territory that belongs to another entity. Now, these rules, again, in theory, do not apply to businesses. They apply to the parties to an armed conflict. But, and this will be the next slide, the violation of these rules trigger a different set of law, known as international criminal law, that criminalize the violation of IHL. And international criminal law not only apply to states, non-state actors, party to an armed conflict, but to every single person, either natural person or legal person, that contributes to the commission of these crimes. So you see here in the table on the screen, the acts that are prohibited by international humanitarian law, which are on the left of your screen, so attacks on populations, attacks on civilians, torture, rape, the looting, plundering of civilian objects, the infringement of the rules on occupations. these violations of IHL by the parties to an armed conflict may in turn become or characterize international crimes, such as war crimes or even crimes against humanity when they are committed in the context of a widespread or systematic attack against the civilian population. And these crimes may trigger the criminal liability to all those who contribute to their commission. So that is the military personnel that would commit the crimes, the political leaders that order the commission of those crimes, but also of businesses who, through their activities, through their conduct, in some way contribute to the commission of these crimes, and they may therefore be considered guilty or trigger the criminal liability for the commission to these violations of international humanitarian law, either as direct perpetrators of international crimes or accomplice of international crimes. They may also, and that may be like a little bit of a different situation, but in some context be criminally liable for benefiting from the proceeds of crimes. For example, looted goods, resources that are looted from an occupied territory and benefit companies that then use them, introduce them in the supply chains, may also face criminal liability. And what is interesting, and what is really something that the French Red Cross guide that we talked about really dwelled on, is that these obligations are not only international criminal law obligations that would trigger liability before international courts and tribunals, but they have been incorporated in most domestic legal frameworks. So in the laws of most national states, which means that the businesses that infringe on this violation may also see their criminal liability engaged before the domestic courts of the states, and especially of the states where the crimes were committed or of the states where the companies are headquartered, are registered. And this is how the Lafarge case takes place, that when we'll talk about it in detail, but the Lafarge case is a good example of how the laws of armed conflict, international humanitarian law, and the introduction of these rules and these principles and these standards into the French national legal framework, French law, French jurisprudence, has triggered Lafarge to now being placed under examination, investigation by investigating judge, and maybe one day face trial for complicity, alleged complicity in international crimes. And so I turn to you, Wayne, to dwell in this in more details.
Thank you, Clara. So yeah, thank you for setting the scene on that. Just to answer the question in the chat quickly, we are recording this and we will circulate the recording afterwards. Over to you, Wayne.
Thank you very much, and thank you everybody for attending to listen to this exploration of international humanitarian law. But more than that, what we really wanted to do was try to bring, if you like, international humanitarian law to a more proximate position in relation to companies, i.e., as Clara spoke about, how does this really impact legal risk? And that, as Clara also discussed, is really largely about international criminal law. So we thought, after setting the scene in relation to IHL obligations and the connection with international criminal law risks, we would examine briefly the Lafarge case in the French courts to try to explain how a prosecutor might start by assessing IHL and then move on, in fact, as they have done, it seems, in the Lafarge case, to another international crime, that is crimes against humanity. Just to say from the outset, we are not arguing they're the same. We're going to explore, though, how a prosecutor might or would approach IHL and then make the next step towards another international crime. So on the 15th of November 2016, Sherpa and another NGO and 11 former employees of Lafarge filed a criminal complaint against Lafarge as a legal person and against its president, Eric Olson, and former president, Bruno Lafont. as well as its Syrian subsidiaries, general managers, before the French jurisdiction. The allegations, as you'll see from slide 9, are really quite extensive, talking about complicity in crimes against humanity, financing of a terrorist enterprise, deliberate endangerment of people, undignified working conditions, and forced labor. In summary, Lafarge is suspected of paying from the spring of 2013 until the end of the summer of 2014 via its Syrian subsidiary about 15 million euros in taxes, in parentheses, and also purchases of raw materials, and paying this to jihadist groups, including Islamic State, IS, and to intermediaries. And the purpose of this, so the allegation goes, is to maintain the activity, or was to maintain the activity of their cement plant in Jalabaya, to be able to pass through the group's checkpoints and buy raw materials needed for production. In a press release, Sherpa, one of the plaintiffs, explained that they were seeking to engage criminal proceedings before the French courts for Lafarge's complicity in crimes against humanity as its financing, so it's alleged, of ISIS between 2013 and 2014 would have allowed the terrorist organization, excuse me, to pursue its criminal conduct in the region, conduct that would amount to crimes against humanity. Now, please have a look at slides 10, 11, and 12 for a chronology of the proceedings to date. November 2016, the criminal complaint. June 2017, the Paris prosecutor opened an investigation for the financing of a terrorist enterprise. June 2028, the case for complicity of crimes against humanity was referred to the investigative judge by the Paris prosecutor, and the investigative judge formally indicted Lafarge. 7th of November 2019, an appeal was lodged against the indictment decision of complicity of crimes against humanity. 7th of September, the French Supreme Court quashed the appeal court's decision I beg your pardon, 7th of November, the indictment decision, i.e. to indict for complicity in crimes against humanity, was revoked by the appeals chamber. But then the French Supreme Court on the 7th of September 2001 revoked that decision. That's important, and I'll come back to that in a moment, because complicity in the crimes against humanity is almost certainly the most serious case that charge that the Lafarge and the accused face. And it is also the one which is most relevant in many ways to businesses and business personnel. In summary, where we are now, judicial investigations are still ongoing. The French courts have confirmed the investigative judge's decision to indict Lafarge for complicity in crimes against humanity. And Lafarge and 4 former executives are to stand trial before the French criminal court for financing a terrorist organization and violating sanctions. So if you look at slide 13, and I'm going to come back to that a couple of times during this brief presentation because it's really critical. After a series of back and forths in the courts have concluded that the standard for the mental element of complicity of crimes against humanity under French criminal law was lower than what the defense argued, and the evidence just gathered during the investigation justified that an indictment be maintained. In short, according to the Court de Cassation, one did not need to show that the accomplice shared the intent of the crimes against humanity. The accomplice need only be aware that the perpetrator was committing or would commit crimes against humanity and that he or she was assisting in their perpetration. And hopefully you immediately can see the problem that creates for Lafarge and creates for many businesses. It's not for a prosecutor to show that by handing over money to the ISIS, that Lafarge intended the crimes. It is enough that they were aware that their contribution would assist specific crimes. As I say, I'll come back to that in a moment. I want to, though, go back in a way. I'll step back and go to the beginning to show you specifically the relevance of IHL and how it plays out in a case like Lafarge. So Lafarge had a cement plant in Syria, located in the north, in a place called Jalabiya, near the Turkish border. As we all know, Syria had been suffering from a civil war that started in March of 2011. Many multinational corporations had withdrawn. And during that period, from 2011 onwards, different armed groups were relevant and in occupation of different areas in Syria. The territory on which the cement plant run by Lafarge, the territory on which stood the cement plant, suffered from attacks from 2012 onwards until 2015. It was occupied by different groups, first by the Kurdish Workers' Party, the PKK, then by ISIS or armed groups affiliated with ISIS, such as al-Nusra. In April of 2013, the region had fallen into the hands of ISIS, which then took the name of IS. On the night of 18th of September 2014, the cement plant was evacuated and ISIS had seized control over it by 25th of September 2014. So what does a prosecutor do with these bare facts? First of all, to ask the question, is this a non-international armed conflict or is it an international armed conflict? For those who attended our first seminar, we spoke about the difference between the two. But it is important to note that in some senses, a prosecutor, at least in the preliminary stages, may not need to dive in deeply into, or may not wish to dive into deeply into that question, because of course it's very complicated, especially in Syria, where you had various states involved, you had various armed groups, and it's quite possible to have a non-international armed conflict running at the side of an international armed conflict, running at the side of an occupation, and so on and so forth. So what a prosecutor is likely to do, and this has happened in some of the international courts, such as the Special Court for Sierra Leone, which tried civil war in Sierra Leone from, I think, 1999 to 1991 to 2001. A prosecutor might just simply say, well, for these purposes, I'm going to assess this as a non-international armed conflict, because I know that in a non-international armed conflict, I'm going to rely upon Common Article 3. Common Article 3, as Clara has discussed, really is the bare minimum of international humanitarian law, which always applies whether it's an international armed conflict or a non-international armed conflict. The rules are different, and international armed conflicts will rely upon a much more developed and specific range of international humanitarian law rules. But if a prosecutor wants to move and maneuver their way through that at the preliminary stages and ask the question, what are the likely war crimes that were committed? Common Article 3, as applicable in a non-international armed conflict, would suffice for that analysis. So Common Article 3 would be seen alongside other serious violations of the laws and customs of war. And if you want to see the full extent of that law, that international humanitarian law that would apply in an international criminal law that would apply in a non-international armed conflict, such as that which may have prevailed in Syria in the relevant period, you would look at Common Article 3, look at the other serious violations of the laws and customs of war, which you'll find in the Rome Statute, and you'll begin to see that quite an extensive range of international humanitarian law, which has been criminalized effectively under international criminal law, which will be highly relevant to any prosecutor looking at whether Lafarge might be responsible for war crimes. So where would that leave the prosecutor? Well, the prosecutor would, having established this overall framework of Common Article 3 and other serious violations of law and the relevant war crimes that are criminalized according to that framework, would then want to look at the facts which are likely to have prevailed. What provisions would ISIS likely have violated and through which kind of conduct? I don't think I need to hold everybody up with a list of ISIS crimes. It's obvious the type of organization that ISIS was. I hope I'm not speaking from the benefit of hindsight. I think it was relatively clear during the time, and this is one of Lafarge's big problems. But there were significant violations by ISIS in the Jalabaya region where the cement plant was. Claims since 2013 that ISIS had routinely targeted civilians, claims that they had routinely detained, arbitrarily imprisoned, tortured, taken hostages, forced displacement, rampant sexual violence, and so on and so forth. ISIS and the creation of a caliphate in and of itself would not amount to a war crime. ISIS attempt to create a caliphate by committing these types of atrocities becomes a different beast. That is a question that the prosecutor would ask themselves. Can we conclude that ISIS, by attempting to create a caliphate, was engaged in criminal conduct? Let's look at the means employed. Let's look at the objective which the means were employed to achieve. Can we see a criminal purpose, which, if it wasn't a criminal act in itself, employed inherently criminal means? These are the types of questions which will be asked in relation to the war crimes. And of course, the more war crimes that could be shown to be established, the more that question is readily answered in the affirmative. So under French law, let me turn to that for a moment. French law criminalizes the violation of certain rules of IHL and the commission of crimes against humanity. So both, either by natural or legal persons. War crimes are defined, as you see in slide 19, as crimes committed during an international and non-international armed conflict, and in relation with the said conflict, in violation of the laws and customs of war or other international conventions applicable in times of war against specifically protected civilians. Crimes against humanity, other than genocide, defined very similarly to the international definition, which involves a concerted plan against a civilian population, a widespread or systematic attack against a civilian population, and enumerated acts such as attacks on life, extermination, enslavement, deportation, forcible transfers of population. So a prosecutor on Lafarge would be asking themselves, okay, it's clear that there are plenty of war crimes being committed by ISIS. That's crystal clear from human rights reporting. It's clear from authoritative commentary from UN bodies and so on and so forth. And then the next question would be, but does that collection of war crimes amount to a concerted plan against a group of a civilian population? Does it amount to a widespread or systematic attack on a civilian population? And have ISIS committed any of the acts which you see in the definition as part of that attack on the civilian population? And as soon as the prosecutor begins to think to themselves, you know what, this is not just war crimes. These war crimes are a policy. They're giving rise to a widespread and a systematic attack on a population, and they involve one or more of these acts. Then any prosecutor is going to start to think, well, this is not just war crimes, it's crimes against humanity. This is more than just incidental war crimes or solitary war crimes. This is a plan to commit crimes against humanity. And that is where the proceedings have ended up. And I'm being careful, I don't want to express, undermine the presumption of innocence, but unsurprisingly, I would argue, unsurprisingly, that's where the prosecutors ended up. But it's not just about identifying what ISIS did, of course. This case is about what Lafarge did and why they did it and with what mental state they did it. These are the most critical questions. These are the most critical questions in almost every war crimes or international crimes case. Not whether the crimes themselves took place, whether the direct perpetrators were committing crimes. That is often a non-issue for the accused or for the prosecutor. That is usually accepted as relatively well established, and an accused focuses on establishing, one, whether they can show they didn't contribute, and two, even if they did, they didn't do it with the relevant mental state. And this brings into real sharp relevance the standards for aiding and abetting, which you can see on slide 20. And this is what I said I would return to during this discussion, because this is where Lafarge are in real difficulty. There are essentially two forms of aiding and abetting in international criminal law. One derives in large part from actually many national states, but also the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, where what needs to be shown in summary is that the aider or abettor substantially contributed to the commission of a crime without necessarily sharing the criminal intent of the main perpetrator. Compared to the ICC and some national jurisdictions where the standard is much harder to meet, and it has to be shown that the aider and abettor not just contributed, but intended to take part in the commission of the crime. The French courts considered this, and the Supreme Court effectively said it's the lower standard. What needs to be shown is that Lafarge contributed whilst being aware that their contribution would facilitate specific crimes. You can see, I hope, the difference and why that creates additional issues and problems for Lafarge. So there are two main elements that Lafarge are facing is, first, by paying 15 million to IS, if they did they contribute to the commission of a crime, and if so, to what degree? And secondly, what was the mental state of those making the payments? Namely, did they make the payment with the intent to commit the act constituting crimes against humanity, or with the awareness that the money did in fact, or would in fact, contribute to the crimes against humanity? Now, I'm running out of time, so I'm going to move through the rest very quickly because I think it's important we have some time for questions. But contributions, again, there is some difference in the jurisprudence. At the International Criminal Court, sometimes they've asked for a significant contribution, a substantial contribution. Sometimes they haven't. At the ICTY and the ICTR, they always asked for a substantial contribution. That needed to be shown. And as far as our research has shown, it's never been shown that contributing large sums in and of itself to the financing of a criminal organization amounts to a substantial contribution. But that does not mean it will not be found by the French courts. And in fact, on the basis of many of the standards employed by the ICTR and ICTY, 15 million to an organization like ISIS would correspond to a substantial contribution. I'm not trying to undermine the presumption of guilt again, presumption of innocence again. What I'm doing is looking at what has been considered to be contributions and significant contributions previously in international courts, and looking at relevant parallels. So, for example, the Popovich case at the ICTY, The commander of the troops had committed international crimes against Bosnian Muslims, and the provision of weapons, fuel for transportation, burials of the victims of international crimes was considered to be substantial contribution. In other cases, the substantial contribution could be political. It can be encouragement, so it can be relatively intangible. Logistics, weapons, and so on and so forth. 15 million, if shown, is comparable. And even more so in the French courts, because in the French courts, what you have is even more loosely or lower thresholds. In the French courts, for example, offering a blanket and a hot meal to a factory worker in order to convince them to burn down a factory was considered to be sufficient material assistance to materialize complicity, despite not being anywhere close to being indispensable to the commission of the crime. Assistance does not have to be indispensable in international criminal law. And as I mentioned a moment ago, even just mere presence at the crime of a scene as a silent spectator can be, if the spectator has sufficient authority, be considered to be encouragement and moral support sufficient to equate to substantial material contribution. Let me just finish very quickly in 2 minutes. Mental contribution. Were Lafarge or its personnel aware of contribution to ISIS crimes? I mentioned it's a low threshold as determined by the Supreme Court and as determined at the ICTR and ICTY. This is a problem because, of course, look at the bare facts. ISIS, well known at any point in time, I would argue, to be an organization engaged in a criminal purpose, which involved a myriad of war crimes and crimes against humanity. 2, handing over 15 million, if that's shown to be true. What else is ISIS going to spend that on? Awareness that it could be or would likely be spent on at least in part crimes. Thereby, therein lies the danger for Lafarge. And let me just end with one comment, because it's, the Lafarge case is an important case because it's not just about IHL violations leading to conclusions about crimes against humanity, complicity in those crimes against humanity. It's also a really interesting case for many other reasons. For example, can Lafarge holding company be found guilty for the acts committed by its subsidiary in Syria? Can a company be regarded as guilty of money laundering for sourcing from a region affected by pillage as a war crime? Can exposing local staff to the risk of bombing be considered a violation of labor law? And so on and so forth. So I think we should all keep a watch of this very interesting case and see how it plays out. And thanks very much for listening.
Thank you, Wayne. And the presentation has got some questions flowing in now. So let's use the last 15 minutes to answer some of those. One of the first questions that we've had is, by providing financing or material support to the parties to a conflict, businesses lose their civilian protection. How does this compare with states financing and providing arms to Ukraine? Are their citizens legitimate targets in Ukraine? I'll hand that to you, Wayne, considering your presence and expertise in Ukraine.
Yeah, I'm in Ukraine right now, so I'm very familiar with this conflict. But forgive me, but the premise of the question is a bit wrong. Simply providing assistance does not make a non-state actor or a state a party to the conflict. And that's the balance that all states contributing to the supporting Ukraine, but also all states supporting any party to a conflict are always mindful of that. If they, and I'm going to be quite general here, if they are assisting, that's one thing. But if they are assisting and that assistance crosses the line into planning or organizing, then they may turn from a mere assister to a party to the conflict. It's not immediate because you hand over, as has happened in Ukraine, of course, even substantial military assistance like HIMARS, like Polanes, etc., or intelligence. It doesn't make the state a party to the conflict, and you see this also in Yemen with the UK, with the US and others supporting the Saudi efforts in Yemen. It doesn't make them automatically a party to the conflict. It has to cross that line from assistance to planning, organizing, and being much more intimately involved. This is a very careful line that has to be drawn, and it explains why states in relation to Ukraine are so reluctant to go further than they've gone, because, of course, arguably, they're very close to that line.
Yes, I think just maybe to complete that, we need to make the distinction between when businesses like corporate actors provide assistance to a party to a conflict, as we discussed before, and the situation where states become a party to a conflict, which are two very different situations. When we talked earlier about the loss of civilian protection, it would be, for example, a situation where you would have a Western arms manufacturer organizing a convoy through Ukraine to deliver weapons to the armed forces. This convoy would be a military objective. They would lose the protection that would otherwise be afforded to the employees of the companies that would, for example, be present in the convoy. That doesn't mean that the state in which this is located becomes a party to a conflict, and therefore that their own territory becomes legitimate target.
Great, thank you both. So moving on to the next question, we've had a question: what is the threshold for when IHL becomes applicable? For example, what is considered an armed conflict? And to what extent might IHL frameworks become applicable for payments to violent cartels for a license to operate, for example?
And that's from Danielle Morley, who I know very well. Let me just start with that, and then I'll hand over to Clara. But the threshold for IHL is different depending upon whether it's an international armed conflict or a non-international armed conflict. International armed conflict is essentially any violent conflict between the states. It could be limited to a single missile attack from one state to another, and that would be an international armed conflict, and IHL would be relevant and applicable. With a non-international armed conflict, it's a bit more tricky, and you're talking about assessing whether the purported parties are sufficiently, so a non-international armed conflict, you're talking about armed groups against states or armed groups against each other. And the distinction that's always made between an armed conflict and a non-armed conflict in that situation would be that if it's a riot or protest or such, that's not an armed conflict. But if the parties are sufficiently organized and the hostilities are sufficiently intense, it becomes a non-international armed conflict, and therefore IHL applies. Generally speaking, those distinctions are not difficult to draw. I've never seen in international courts, at least, any real argument about these when it's become applicable. I've certainly never seen an argument win, at least, as to parties arguing that IHL wasn't applicable. Just looking at the second part of the question, to what extent might that be?
Yeah, to what extent might IHL frameworks become applicable for payments to violent cartels for a license to operate, for example? And I think this is something that we see a lot in terms of payments to groups that are operating in conflict and high-risk areas. So when might IHL frameworks become applicable?
Well, really, it's based on what I just said. It's not so much on the nature of the payment. It's about whether, for example, in this instance, the violent cartel is in conflict with the state or other organized groups, and those hostilities are sufficiently intense, and the violent cartel is sufficiently organized, then IHL becomes applicable. And obviously then the payments to the violent cartels would have to be assessed through international humanitarian law. I would also add, just on this before passing to Clara, crimes against humanity, it's a different kettle of fish, because you don't need in international criminal law an armed conflict. Crimes against humanity can be committed without an armed conflict. Clara, I don't know if you have anything to add.
I completely agree. I think this question is also very interesting because it shows that there is like the line between international criminal law and other areas of law is becoming more and more blurry, and that goes, we said earlier, about like corporate liability, white collar crime, corporate crime, but also when it goes to organized crime. And it's true that at this stage we don't have jurisprudence that considered that an organized crime organization such as a cartel could become a party to an armed conflict because their level of organization and the intensity of the hostilities that they might be engaging with the state reached a threshold of becoming an international armed conflict. But with the development of new forms of conflictuality and hostilities, and like a blurred line between when an organized crime group becomes a terrorist organization, become an armed group, we might see this law also evolve based in the practice and in the factual situation on the ground. So that's really something that that we're keeping an eye on. Now, providing material support, financing to a cartel would still be a crime in most countries and domestic legal systems.
Oh, and we've lost her.
Oh, we lost her. Yeah.
On that point. So maybe we'll just if she joins back, then we'll let her finish the point that she was making. But in the meantime, just to think about what the role of investigations is in this, in terms of both proactive and reactive steps that businesses, investors, and others can take. So yeah, what is the role of investigations in preventing corporate complicity?
Let me try to answer that because it's a sort of subject which is close to my heart in a way. We're increasingly seeing organizations like Sherpa bring cases to national prosecutors, and then national prosecutors, of course, often or increasingly often.
I'm sorry, I think I lost you halfway through.
Okay. Do you want to finish that, Clara? Then sorry, go on.
No, I'm not quite sure where you lost me. But I was saying that providing military or financial support or any kind of material support to an organized crime group would still be a crime in most jurisdictions, although it might not be complicity in war crimes. As you said, it may characterize complicity in crimes against humanity if this organization is involved in mass crimes against a civilian population. But it might also be like just more domestic law, common law crimes, such as complicity in other types of criminality, or just even providing support to a criminal, an organized criminal organization that is a crime itself in a lot of jurisdictions.
Great, thank you. And so maybe we just use the last 3-4 minutes before we close out for that question, Wayne.
Yeah, so we're just considering the role of investigations in, I think, protecting companies from these types of allegations. I think there's I increasingly see a mismatch between the way that activists NGOs like Sherpa, and activist prosecutors like some of the French courts are operating in terms of hard-nosed investigations into known risks or risks that should have been known, harm that has resulted as a consequence of contributions, and so on and so forth, vis-a-vis the actions of corporations. And I think there's a sort of, in a way, there's a lacuna in the way in which business and human rights is currently practiced, in that investigations do not seem yet to have been accepted as an essential part of protecting companies from allegations. Heightened human rights due diligence is, of course, increasingly understood in one sense, or at least increasingly accepted as the minimum that companies need to do to protect themselves in conflict-affected and high-risk areas. And that, as many of you will know, involves not just assessing the risks that a company faces, but also assessing the dynamics of the conflict and understanding the interaction between the conflict and the company, and understanding the interaction between the conflict and the business activities. And then, of course, afterwards, designing activities or designing business approaches which take on board those risks, avoid harm, or mitigate the harm. Yet, if you look at the material which describes that from the UNDP conflict heightened due diligence paper to UN guiding principles and so on, the role of investigations has not been properly explained nor understood. Personally, I don't believe that you can do heightened due diligence without conducting investigations. And investigations are a critical tool alongside stakeholder dialogue, stakeholder engagement, alongside assessing conflict dynamics. It's simply not possible to bottom out all the risks or understand the harm unless you're prepared to move forward with investigations. And when I say move forward with investigations, the human rights fact-finding methodologies, international criminal law methodologies, these are critical tools that are necessary in many heightened due diligence processes, without which I think the activist NGOs and the national prosecutors are at a major advantage compared to corporations. This is, I think, something we should talk about in a future seminar, because I think it's a really relevant issue, and companies need to move towards this type of investigations if they are to comply with their obligations, in my view.
Thank you. Well, that's all for
One
today's.
more question, I think.
Oh, have we got one more? Okay, what is the role of the home state of corporations in limiting their corporate actors getting involved in international crimes such as those operating in occupied territories?
Gosh, that's another seminar in itself. I don't know if you want to go with that.
I mean, under the Geneva Conventions and most international humanitarian law treaties, states have the obligation to prevent violations of IHL and to prosecute those responsible for this violation. Now, they have this obligation, and the breach of this obligation may trigger the state's responsibility, the state's liability. But the way they are enforcing or respecting this obligation varies so much from one state to the other, and it's also very, very much based on their own national and domestic laws. And there is, for example, like a very big difference between countries like France, where a corporation may see their own criminal liability triggered, like the corporation itself may be criminally liable for contributing to or benefiting from an international crime. And there are countries like Germany, I believe, where corporations are immune from prosecution, and it's only the corporate leaders, maybe the management, like persons within the company that may face prosecution, like before international courts, for example, where like companies, legal persons themselves cannot be prosecuted, but it would only be the person. And so do states need to update their laws, update the national systems to take into consideration these new forms of conflictuality and new forms of responsibility, or a way like different actors have an impact on wars and the conduct of hostilities? I believe it's much more of a political maybe question than legal. And I do not think, or at least we are yet to see any states being brought before either the ICJ or even the ECHR for violating their obligations to prosecute or to ensure that the businesses registered in their jurisdiction comply with IHL. But that would be an interesting case to take on.
Great, thank you. So we're 2 past the hour, so we will wrap up there. If you have any further questions, please do feel free to send them through. I want to extend a sincere thank you to our panelists for sharing their expertise and their insights, and to all of you for joining and contributing with these thoughtful questions. I think what's clear from today's conversation is that the intersection of IHL and business is complex, it's evolving, and it is relevant. And while there are challenges that remain, there are lots of opportunities for companies to proactively align their operations with the legal frameworks that exist and ensure respect for human rights in conflict-affected and high-risk areas. This seminar series is always about fostering these discussions. So we hope today's session was really helpful, and it provides you with some perspectives to take forward in your work. We will be continuing this conversation in our next session next month, where we will be talking about the responsibilities of businesses operating in occupied territories. So stay tuned for the details on that. And in the meantime, if you have further questions or would like to continue the discussion with any of our legal advisors, please do feel free to reach out. My email is in the chat now. So thank you again for taking the time, and we look forward to seeing you in our next session, hopefully. Thank you.
Thank you.